Right. Yes, Ms. Bottle.
I'm going to take the court now through the respondent's submissions on whether Rule 3221A was correctly applied. And I'll take my lords and my lady through the authorities relied upon by the
Yes.
and the rules themselves before making some broader submissions. So if I could begin firstly with the authority of Mahad.
Yes. That's tab 1, isn't it?
That's right, it's the first tab in the authorities manual. And if I can draw the court's attention to page 9.
Yes.
And here in Lord Brown's speech, also referred to by my learned friend, his lordship sets out some principles of interpretation.
Yes.
He says at B, essentially it comes to this: the rules are not to be construed with all the strictness applicable to the construction of a statute, but sensibly according to the natural and ordinary meaning of the words, recognizing that they are statements of the Secretary of State's administrative policy. His lordship continued that the Entry Clearance Officers Council readily accepted that what she meant in her written case by the proposition, the question of interpretation is what the Secretary of State intended his policy to be, was that the court's task is to discover from the words used in the rules what the Secretary of State must be taken to have intended. And his lordship explains that that is because, of course, under the 1971 Act, the Secretary of State has to lay the rules before Parliament, which then has the opportunity to disapprove them. So the point that I wished to make is it is not simply a question of the ordinary meaning, but the court is also considering what the Secretary of State intended in laying those rules before Parliament. The next authority I wanted to take the court to is behind tab 2, and that is, pardon me, not tab 2, tab 5, and that is
Yes.
Khan.
Tab 5.
Yes, my lord.
Khan, yes.
Khan, yes. In that case, the appellant's application for leave was refused because he did not meet the mandatory financial requirements at the time that he varied his application.
Yes.
And the court was concerned with whether the requirements of the rules applied as at the date of the original application or the date of the variation. And the decision turned on paragraph 34E of the rules,
Yes.
which we've considered, which is headed variation of application.
Yes.
And the point which I wanted to make is one which my lady noted, which is, of course, that in Rule 34E, it makes clear that, well, perhaps we should turn to it now, in fact.
Well, if we look at 34E in the authorities bundle, it's at page 185 behind tab 9.
Yes.
But it may be set out in Khan, is it? I don't know.
Paragraph 5 of
It's
Khan.
paragraph 5 Khan, that's good enough, isn't it? It's the same. It's the same version, isn't it? So page 80.
Yes, that's right. It's right there at paragraph 5. And of course, the rule states that if the person wishes to vary the purpose of an application, the variation must comply with the requirements of the paragraph, as if the variation were a new application or claim. And I think my ladyship made the point this morning that inclusion of that phrase, as if, underscores the point that it is not, in fact, a new application. that is because the requirements of paragraph 3C, which I'll come on to in a moment, mean that there's only one application in play at a time, and so therefore it is not a new application but simply a varied application. And to maintain that fiction, it's necessary then to tinker around the edges of that, and at Rule 34E, to ensure that the decision maker takes into account the varied application, inserts that clause as if it were a new application, because it is not.
Yes. Having said that they're the same, they're not actually.
Yes,
I blame Lord Justice Lewis for that, not either you or I, because he
I'm reading them both. I thought
they are they literally look alike.
Oh, no, they're not.
They're not
You're
the same
right.
because they're drawn differently. I don't think it probably doesn't matter. Do you see?
Yes, well, I had honed in on the phrase "as if" the variation.
Well, I
were a
don't
new application.
expect that that's
That's
going,
the same in both.
going to change, but we better just cross check this.
Yes, it is.
So what happened on the one we've got now is that there's a comma after United Kingdom, and then the passage the words "and an application form is specified for such new purpose," or paragraph A34 applies, isn't there? Then it says the variation must comply with the requirements of, here it says paragraph 34A or paragraph A34, but now it just says paragraph 34. Now, I don't think it matters, does it?
I don't think it matters because I think what you're relying on is the fact that it talks about the variation. It doesn't treat the variation as an application in its right. It treats it as a variation. And as my lady pointed out, it introduces a fiction as if that variation were a new application.
It's pardon.
And the point of this is that the rules in your submission are meant to say how sequential events are to be treated. If a person says, I want to stay in the United Kingdom because I'm an entrepreneur, and then a few weeks or months later they say, oh, I want to stay now because I've been here for 10 years. The question is, how does the law deal with those two states of events? Mr. Malik says it's one application and a new application. You say it's one application and the law treats the later one as a variation for all the reasons that we've seen. That's your essential case.
Exactly.
And the
Exactly.
purpose of this is, and I got this right, is that the new application, the variation application, must comply with all the requirements of a new application.
No, the
not?
requirements have to be assessed at the time that the variation was put in.
Yes.
So it's not enough if you had enough money 10 years ago when you made the original application. You've got to satisfy the requirements as at the time the variation is made.
As if it was a new application.
Yeah.
Right.
Yes.
That's as I understand what the law
Yes.
is driving at.
Yes. In common. Yes, the issue is slightly different. Well, was different to what we have here, and it's that the requirements, the financial requirements, had changed between the time of the original application, if I could put it that way, and the varied application. And the question was whether he had to satisfy the requirements as they were at the time, or whether he had to satisfy the requirements as they were when he varied his application.
Yeah.
So then there was a question, well, if it's just one application, couldn't I rely on the rules as they were when I put in the initial application? But the rules have tinkered with this particular requirement and said that, in fact, even though it's all one application and even though you're just varying it, you are held to the requirements as they were at the time when you varied the application. None of this, I think, really bears materially on the issues we're considering today, except to say that the fact that the rule includes this phrase as if the variation were a new application, reinforces the idea that it is not actually a new application. Because the scheme under the rules is consistent in my submission, that there is no new application because there can only be one outstanding at a time.
Thank you.
That is all I wish to say about Khan. Next, if I can move on to the authority of JH, the relevant page is page 62 of the authorities bundle. JH, this is a judgment of Lord Justice Richards,
Yes.
with whom both Lord Justice Wall and Lord Justice Laws agreed. And the appeal concerned the same sort of issue, whether a second application may be treated as a variation of the first application, or whether it stood alone. The appellant in this case applied for leave to remain using the incorrect form. She had applied using a form seeking indefinite leave to remain, which she plainly didn't qualify for. The Home Office noticed the error and invited her to apply for a limited leave to remain, sending her the correct form. And the question which arose finally on appeal was whether there was jurisdiction to entertain the appeal at all, because if her second application, if I can put it that way, had stood alone, she would not have had any leave at all at the time that she made the application. And so when it was refused, she wouldn't have had a right to appeal against the refusal. And so the question arose whether that second application, on the correct form, was a variation of the first, or whether it stood on its own.
Mm.
And I know the court has already been taken to section 3C by my learned friend. The Lord Justice Richards explains how section 3C is to operate at paragraph 35 of the judgment. And this is, I don't think my learned friend would demur from this. This is settled case law now. So Lord Justice Richards' conclusions here at paragraph 35 on how section 3C is to operate are settled. It's
Definitive.
definitive, yes. So his lordship held that the key to the matter is an understanding of how 3C operates. By subsection 1, where an application for variation of an existing leave is made before that leave expires, by subsection 2, a statutory extension of the original leave is made until the application is decided or it's withdrawn. If the application has been decided and there is a right of appeal against that decision, the time for appealing has expired, or if an appeal has been brought, that appeal is pending. During the period of statutory extension of original leave, by subsection 4, no further application for variation of that leave can be made. There can only be one application for variation of the original leave, and there can only be one decision. The possibility of a series of further applications leading to an indefinite extension of the original leave is excluded. However, by subsection 5, it is possible to vary the one permitted application. If it is varied, any decision will relate to the application as varied. But once a decision has been made, no variation to the application is possible, since there is nothing left to vary. So his lordship's conclusions explain that it is in effect necessary for the second application, if I can, to be considered as a variation of the first, so that section 3C operates to extend the person's leave until the decision is decided, until the application is decided. If it didn't operate that way, if somebody had to change or vary their application because of a change of circumstances, which could be no fault of their own, then they would not have leave anymore, and that would have serious consequences for whether they could appeal, for example. So it's necessary for the statute to operate in that way. And in my submission, looking at the remainder of the rules, which I'll take you through in a moment, it's clear that principle of there being a single application which is outstanding applies right the way through the rules as set out by the Secretary of State. And the key question is whether a decision has been made on an application. If there hasn't been a decision made on it and another application comes forward, then it is to be treated as one application, and it is a variation of that one application. The key question is whether a decision has been made on the application or not. As my lord noted, this varied application will be on could be on a different form. It needs to comply with all the requirements of the rules in place at the time. It looks, for all intents and purposes, as if it were a standalone application, but that doesn't change the essence under the statutory scheme, which is that it is treated as a variation of the first application. And Lord Justice Richards deals with some of the sort of practical difficulties which arise in the terminology because of this sort of legal fiction. He deals with it at paragraph 42.
42, did you say?
Yes, paragraph 42.
Thank you.
Where he says, I have referred throughout to the question of whether a later application can be a variation of the first application. That language may be technically inaccurate since section 3C precludes any later application, though section 3C5 allows a variation. In practice, however, a variation has to be applied for in exactly the same way as a standalone application, using the same prescribed form. And I do not think that any difficulty is caused by referring loosely in this way to the possibility of a later application constituting a variation. So it is sometimes necessary to refer to the variation as an application, if I can put it that way, but that doesn't change the operation of the statutory scheme in that it is in fact a variation. You need some kind of language to refer to both, if I can put it that way. But that's not to say that they aren't treated in law as being part of the same unified application.
Right.
I think that's what I hoped to say about JH. If I can then move on to the rules themselves. So beginning with page 184 of the authorities bundle. Rule 34 double B, which is headed multiple applications, states an applicant may only have one outstanding application for leave to remain at a time. And if an application for leave to remain is submitted in circumstances where a previous application has not been decided, it will be treated as a variation of the previous application. So this is, in my submission, the sort of encapsulation of what Lord Justice Richards' judgment in JH was driving at, that this puts on the rules set out exactly as he had intended, that there is only one outstanding application at a time, and that the question is whether that application, the first application, has been decided. And if it hasn't been decided, that's the key issue, then that second application will be treated as a variation of the previous application. And in my submission, this rule entirely supports the respondent's interpretation of the rules.
Well, the thing is, you can only have one application, and if you've got two documents headed application, what do you do? And you say this rule says you treat the second one, the second document, as a variation of the first one.
Yes.
If that were not the case, you would have two outstanding applications.
Yes. And then moving on to page 185, we have Rule 34. This was the provision, forgive me, which we dealt with in Con.
Yes.
This was the, now we know, the slightly modified version, which was in force at the time, which I've already made the point, but is in keeping with this scheme because it says as if the variation were a new application,
Yes.
except
Well,
that it isn't.
The oddity is the new rules don't have that heading. There can only be one outstanding application. The new rules, which I imagine is why Mr. Malik refers them to the rules in force at the time, doesn't have that requirement that there's only going to be one outstanding application. And it does talk more about previous applications and the recent application as if they're two continuing things. So do you know why the Secretary of State has done that?
I don't have instructions on this particular change, I'm afraid. And I mean, I can see, of course, why my learned friend has referred to this version, but as my lord noted this morning, this wasn't the version in place at the time. The version in the bundle was in place at the time when the old Part 9 was in force. And so if the court looks to different versions, which wouldn't have been contemporaneous, if I can put it that way, there's a risk there of a mismatch, if I can put it that way, between, you might find a conflict between different parts of the rules, but that could be because they weren't supposed to be in force at the same time anyway. The court should be looking at the rules as they were when the decision was made.
Well, we're looking at the interpretation of Rule 3221A, which hasn't changed in its wording at all. And we're looking at what that meant on the 21st of May 2021, or whenever the decision was reached. And if we're looking at the rules as a whole to see what it meant as at May 2021, then I suppose we've got to look at the rules in force.
I mean, 32218, I might be misunderstanding, my lord, but Rule 32218 did change after the decision was made in this case. So there's
Yes.
now a new Part 9.
Is it the same rule? It's called Part 9 now, not 32218A. Has the substance of it changed?
There are some changes. I haven't.
That's fair enough, because that's not what you've come to deal with.
No.
But we've got to interpret the rules as at whatever date it was. And it'd be odd to use changes after that date to find out what it meant before that date.
Yes, precisely. And especially if you're looking at changes at one part, not being cognizant of what
Yeah.
changes might have been made to different parts at the same time. So I would just urge the court to look simply at the rules that weren't. So that deals with 34E. And now dealing with 32218,
Yeah.
which is at page 192. (32218) is part of the mandatory refusal. So it's grounds on which leave to remain are to be refused. And it states where false representations have been made, whether or not material to the application, and whether or not to the applicant's knowledge in relation to the application. So the first thing I draw the court's attention to is that this provision permits or requires a mandatory refusal where the false representations are made, whether or not they are material to the application. So that is quite a serious sanction, if I can put it that way. And my learned friend made the example this morning of an individual who makes an application and includes a document which isn't even required or isn't material to the grounds that he needs to satisfy to obtain leave. But the fact that that document contains a false representation would be enough to require mandatory refusal. That is important in my submission because it means that the Secretary of State views the use of false representations, which are made in applications, as so serious that even where they are not material to the application must be refused. And this plays into the policy considerations, which my learned friend made submissions on this morning. He made the point that there are policy reasons why the Secretary of State would want, in fact, to be able to exercise a discretion if the false representation was made in relation to an earlier application and not in relation to the varied application. So he used the example of somebody who might have used a false representation in an entrepreneur visa, let's say, but then went on to form a relationship with a settled British child. The Secretary of State would want to be able to exercise a discretion. My submission, that cannot be right, because under the rules as they are, false representations require a mandatory refusal, whether or not they are material. So it's not the case that the false representation has to be material to the application. The fact that it's made is enough to require a mandatory refusal. So looking at my learned friend's example, the person who then goes on to form a relationship with a settled British child, their application should still be refused because it's a mandatory refusal ground, which the false representation does not need to be material to their application to remain. So the way in which Rule 3221A is framed means that the Secretary of State has an automatic refusal of such applications, whether or not they are material. And if no decision has been taken against an application, as here, then on my learned friend's analysis, the Secretary of State would be deprived of the opportunity to refuse on the mandatory basis. And in my respectful submission, there's no reason why that should be so, because the rules provide for mandatory refusal whether the false representation is material to the application or not. And so on a true reading of Section 3221A, the Secretary of State should never be deprived of the mandatory refusal ground where she has not yet taken a decision in relation to an application. The fact that an application may later change because of a change of circumstances should have no bearing on that mandatory refusal, because the false representation does not need to be material to the application. The other point I wish to make is my learned friend made the submission that if 3221A was to apply to the appellant's situation, then it should be phrased to say any application, or I think the other word he used was a previous application. But if that were so, then that would mean that the rule would encompass applications on which the Secretary of State had made a decision already. And that's not what's intended here, because we have that provision, and it's not a mandatory refusal, it's a discretionary one where a decision has been taken on a previous application. So the wording which is appropriate to the appellant's case is the wording which is used here, which is the application, because the varied application is part of the whole. And if we called it, in this context, a previous application. There would be no way to distinguish between here, where you have a varied application and no decision's been made, and somebody who used a false representation in an application which had been decided 10 years ago. And that's obviously not consistent with the scheme of the rules, which has mandatory refusal for applications which haven't been decided and discretionary refusal for applications where the misrepresentation is in an application which has been decided previously. Turning then to the guidance, which my learned friend relied upon, which appears behind tab 10 of the authorities bundle. And the relevant page is at the very end, page 206. And it says false representation in a previous application. If the false representation was found to have been made by the applicant in relation to a previous application, or a current application for entry clearance must be refused, and a current application for leave to remain should normally be refused. And my learned friend seeks to draw support for, if I can put it this way, his interpretation of Rule 3221A. I think the basis is that this reference to a previous application would include the appellant.
Yes, he's suggesting, I think, that the phrase previous application here should be interpreted consistently with the way it's used in 3221A. Is that right?
Yes, but yeah, I mean the difficulty with that is 3221A just talks about the application, and as the submissions that I've made is that the rules, if you look at them as a whole, make clear that an application which is made after one which hasn't been decided is a variation of a first. So it wouldn't be correct to describe the appellant's application for his Tier 1 visa as a previous application because it hadn't been decided.
Well, that is the question. The question is it something that's meant to be a previous one, or is it a varied one? And all this says is if it's a previous one, the guidance applies. If it's not a previous one, it doesn't. It doesn't help you to answer the fundamental question.
Yes,
It's
exactly.
parasitic on the answer to the question.
Yes, exactly. So I don't think it takes matters any further. It tells you what you should do with a previous application, but
It's
it
not 3221A where the phrase appears. It's 34BB. That's where the phrase previous application appears. And I think he's arguing that it should be interpreted consistently.
Yes, but I suppose the problem there is that 34BB says specifically that if the application hasn't been decided, then it's a variation of the previous application. So all going to the point that there's only one application in play at the time. But perhaps, my lord, the better way to think of it is that the guidance itself doesn't define what a previous application is. It doesn't, in my submission, take matters any further. It just says what you should do once you know what the previous application is, if I can put it that way. And according to the authorities, it's only, in any event, according to the authorities, it's only in cases of where there is a genuine ambiguity that it would be correct to refer to the guidance in any event. So
Do you think, is it your case that previous application in the guidance refers to previous applications which have not been decided, or previous applications which have been decided, or both?
previous applications which have been decided.
So therefore it's not the same as in 34BB. Sorry, it's the same. Not been decided, you say.
Yes, it's, yes.
It is the same. It means that it is being used in the same way. Have I got that right? You say
Well-
it's previous applications that have not been decided. That's what the guidance means.
The guidance is referring, no, pardon me, the guidance is referring to previous applications which have been decided.
Right. So that's not what 34BB is talking about. We're just talking about previous applications which have not been decided.
Yes, because, and it specifies that they're to be treated as a variation of the first. Pardon me.
But that's what your submission is, that guidance about how previous applications should be treated when they have been decided doesn't help us determine how to interpret provisions about previous applications which have not been decided.
Yes, that's right.
Thank you.
And I think I'll just take you very briefly through the authorities which deal with how the guidance can be used to interpret the rules, because there's some submissions that my learned friend has made that we don't quite agree with. If I can take the court to, not sure how to pronounce it, Pokiral, which is,
It's tab 2, is it?
yes, and page 28 of the bundle.
Well, we looked at paragraph 42.
Yes,
where Lord Justice Jackson cites from Adedoyin
that's right.
and what Lord Justice Ricks had said, and says he agrees with it.
Yes, exactly.
And
What I,
adds,
what I wanted to emphasize, my lord, is that there is a, at the very beginning of paragraph 42, if there is ambiguity in the immigration rules and the Secretary of State publicly declares that he or she will adopt a more lenient interpretation, then the tribunals and courts can hold the Secretary of State to that assurance. And then the example in Adedoyin is reference to the term false representations. And the relevant minister said in Parliament that false in this context meant not merely incorrect, but deliberately false. And there were other public statements by government officials to similar effect. And when the Court of Appeal construed the rule, they took account of those assurances. That is very far removed from the case, from the appellant's case.
so it's not just that approach is not wherever there's an ambiguity, but wherever where there is an ambiguity and the Secretary of State has given that indication about lenient interpretation.
Yes, exactly. We wouldn't accept in any event that there is an ambiguity within the immigration rules. We
You don't accept there's an ambiguity.
No, precisely.
If there is an ambiguity, there's been no indication by the Secretary of State that a more lenient interpretation is to be preferred in this instance.
Precisely.
Is that all we need to worry about with Pokiru, however you pronounced it? Pokiru?
Yes, I think so.
Was there another authority on interpretation that you wanted to refer to?
No, just Mahad, which we've already gone through.
Right.
So I think that's it. The final submission that I wanted to make, which I think, in fact, I made before the lunch adjournment, was that the judge was also correct to note that the alternative general ground of refusal which is not the mandatory ground of discretionary ground, wouldn't have applied in the appellant's case either. And that was support for his conclusion that it was actually Rule 3221A which did apply.
Well, I was thinking about that over the lunch hour, and I see the force of what you say, that 3222 talks about the previous variation of leave, which must mean the leave, not some application for leave. But why wouldn't it come under 5, even if it's not the making of false representations for the purpose of obtaining a previous variation of leave? Why is it incapable of being the undesirability of permitting the person concerned to remain in the light of his conduct? Because the conduct, even if it doesn't give rise to a 322 situation, is still undesirable. The Secretary of State and most people, I suspect, would expect people to be honest in their dealings with the Home Office.
Forgive me, my lord. 3225.
I understand that it won't come into 3322 because you say that refers to the previous variation of leave,
Yeah.
which must refer to the things that happened prior to 2013. But the same thing, the making of a false representation, could be conduct, because the Secretary of State may well take the view, and people may take the view, that you should be honest in your dealings with the Home Office. And if you say, I'd like to remain in your country, the quid pro quo is you're honest about the circumstances. So if you're not honest, subject to the degree of honesty and the other factors, it could fall within little 5, couldn't it?
Yes, and I think, in fact, if I'm not mistaken, the Secretary of State does use paragraph 322, subsection 5 in this case as another basis.
Mm-hmm.
Yes, but I suppose the question is whether 3221A and 3222 are two parts of the same sort of provision. They both deal with the making of false representations.
And you say the one deals with the previous variation of leave, that's 322. It's water under the bridge, but it can still be a discretionary ground.
Exactly.
But if it's an application which hasn't yet been determined, then it's mandatory.
Yes, exactly. And so, though my lord is right that 3225 would also be applicable, because 3221A and 3222 are part of the same, two sides of the same coin, if I could put it that way.
You
one
say
of them must be
1A
applicable.
captures undetermined applications, 1B captures previous but now discovered falsehood in connection with previous leaves that have been granted.
Yes, and the Secretary of State must have intended that one of those two provisions would apply if a false representation was made in the course of an application.
Your submission is it would be odd. You can lie about an application, but if you put in a new application, it doesn't matter. It can't be caught by 3222, and it doesn't fall within 321A. There would be the same, in inverted commas, wrong thing, falsehoods.
Yeah.
But there's no basis for that falsehood alone justifying a refusal.
Very odd, indeed. One final point that I wish to make in respect of 3221A is that my learned friend in his submission criticizes, in effect, the Secretary of State for the delay in taking a decision in relation to this case. That is why a variation happened, because it had been such a long time. And I think he sought to derive some support for the notion that the mandatory provisions shouldn't apply anymore because there had been such a delay. And of course, in this case, the delay was caused by the police operation, Operation Meeker, and the subsequent prosecution of the 6 defendants, which are specified in the First Tribunal judgment. And of course, it's right that that operation should run its course before the Secretary of State takes decisions on false representations made in the applications. And so in my submission, it would be unfair to criticize the Secretary of State for taking time to decide that application. She was required to let that criminal process run its course. Had she written to applicants in the intervening time frame, refusing their applications on the basis of false representations, not forgetting that she's required, of course, to disclose the evidence upon which she determines that false representations have been made. If that process were ongoing at the same time as the police investigations and prosecutions, there could be a compromise to those operations, with some defendants getting evidence against them at a time when other defendants were still going through the process, if I can put it that way. So it was proper for her to wait until that criminal investigation had run its course. Moving then, I think, to the question of whether the ground of appeal is academic. I think
You want to do 3225 as well, the 2-stage inquiry? You want to go to 226, do you?
I can
276.
I can do it in that order. If that, I'll do that.
The 3225 doesn't apply on your case because it's a mandatory case.
Yes, that's right. It's a mandatory case. But that's right. But ground 6, upon which the appellant was granted permission, of course. Just pull up my skeleton.
Can I ask maybe a naive question? Please tell me if it's wrong, Ms. Pottle, because you have much more experience in this area than I do. But if a decision maker or a tribunal decides this was false representation, so that the case falls within 3221A, how can it then arise for consideration as to whether it falls under 3225 and should be treated in the way that 3225 decisions have to be?
Well, if I'm right and 1A applies, then it's not necessary to go down that route. But the judge, and as they often do, took into account different alternatives in case he was overturned on appeal on one of the possibilities.
What is said is that by Mr. Malik is that the judge failed to apply the proper balancing approach which was necessary, taking into account on the one hand the culpable conduct, on the other hand the positive factors.
Yes.
Now, if the culpable conduct is as found by the judge to be and accepted to be the making of false representations, how does that balancing exercise arise?
Well, if I'm right and the mandatory provision applies, it doesn't arise.
Okay.
That's right.
But yours, this is the course that tribunals commonly take. You know?
Yes.
It just seems a little surprising that they do, having reached a factual decision that there was false representation, admitted false representation,
Yes.
but nonetheless go through a balancing exercise which balances positives against something which is a knockout blow on the way the rules are drafted.
Yes. I think maybe there's been a misunderstanding.
You mean by me? That's a very delicate way of putting it.
I just feel that these rules are, the interpretation of these rules is a very turgid subject, and I hope that my learned friend and I have done our best to make it lively, but I know that it isn't really. If Rule 3221A applies, then it's a mandatory refusal, and that's it. But if 3221A doesn't apply, then it's a discretionary refusal. And
Yes.
that's where you have to take into account the balancing exercise. Even if it's fraud, the question of that there has been a fraud is not, that's common ground between us. There's no round of appeal that the appellant has been granted permission for in respect to that. So it's a given. The question of whether 3221A applies is completely tied down to the question of whether the application was a new application or not. That's it.
The one with the Secretary of State did decide on 3 grounds reading the letter, 321A and 3225 and 276B.
B2.
He actually, to be fair to the tribunal, the Secretary of State had gone through.
Yeah, so it's obviously commonly
Yes,
done in that
yes.
way.
In case they lose on one of them, they have all the alternatives to avoid the situation in which we find ourselves, which is that if the appellant succeeds or might succeed on a single ground, having to start all over again.
All right. Okay,
And
I follow now. You did put it very delicately, but I can see where my thinking can run into the sand. Anyway, develop your point on 3225.
Yes, 3225. So the issue on 3225 is whether the reasoning, the appellant argues that under Balajagari there should have been this 2-stage test applied, and it wasn't, the appellant argues, there wasn't the 2-stage balancing exercise, wasn't taken out. And therefore, even though, as I understand it, the appellant seems to accept that he'd have an uphill struggle, his submission is that this court should remit the matter back to the Upper Tribunal to conduct the balancing exercise, which it's required to do under Balajagari. The respondent's submissions are, well, firstly, that the ground of appeal is academic. I'll deal with that separately. In the alternative, the respondent's submissions are that the First Tier Tribunal's reasoning was adequate, although it was brief. And finally, even if the court finds against me on that, and the reasoning was deficient, according to the law, then the respondent's submission is that any error was not material because the appellant's case, in effect, is so weak that any tribunal would be bound to refuse. If I can begin by going to the authorities, in Balajagari, the point I'd like to make is that the appellants in those cases had submitted figures in their applications to the Secretary of State regarding their earnings, which were discrepant with the figures that they had submitted to the revenue. That was the false representation.
The discrepancy.
The discrepancy, precisely. So a world away in my submission from the dishonesty with which this court is concerned. Also in Balajagari, the Secretary of State did not inform the appellants that she regarded their conduct as dishonest. She did not give them the opportunity to provide an explanation. Here, of course, the Secretary of State wrote to the appellant setting out the allegations. There was lengthy correspondence. The appellant responded to, I think it was 35 questions with the aid of legal representation, and then there was the long reason. So we are, in this case, considering a very different kind of factual background to the one in Balajagari. Similarly, in Yassin, the
It
relevant
was not sending tax returns, failure to file tax returns.
precisely. So it was the relevant conduct was a failure to make a timely tax return.
Right.
And the appellant in that case also had not been given the opportunity to respond and explain the failures. And if I can take you then to Yassine paragraph 35. It's tab 7. So the respondent advanced a list of factors in that case that should have been weighed in the balance. That the applicant had made accurate tax returns, that he had long residence, that he lived a self-supporting and law-abiding way, that he had behaved properly in relation to his tax liabilities since the index event. He had a good work record, high educational achievement, and good references. And he argued that these were significant matters to weigh in the balance. Now, what I'd said in my skeleton was that the appellant had not put forward any additional material which should have been weighed in the balance. But my learned friend has tried at least to remedy that in his submissions this morning. It's the difficulty with putting too much in your skeleton argument. He has put forward some matters which he says should have been weighed in the balance, which I'll go through now. The first element which he says which should have been considered is the timing of the misconduct in question. In my submission, looking at the judgment as a whole, there's no question that the First Tier Tribunal judge knew when the alleged dishonesty was said to have occurred. He carried out a lengthy recitation of the evidence which he heard, because of course there was a dispute about whether the allegations were true or not. So it's clear that the judge knew that the dishonesty had happened some time ago, that there was a delay while Operation Meeker was allowed to run its course. The length of the residence is something which the appellant was required to have in order to qualify for leave under the long residence rules. So he had applied for indefinite leave to remain on the basis that he'd been in the UK lawfully for 10 years. The issue in the case was that, not that he didn't satisfy the 10-year requirement, but the issue was that his conduct was not, he didn't satisfy the conduct requirement. So there can be no question that the fact that he'd been in the UK for 10 years was a part of the considerations of the judge and indeed the Secretary of State when they came to determine his application. It's not something which could reasonably also form part of the balancing exercise. It's a requirement in every case. They would have to be here for at least 10 years. Similarly, my learned friend relies on the nature of the residence, so the fact that it was lawful. But again, that is that's required under the rules.
That would be that was a requirement in any event.
Yes, exactly.
So,
The third matter, I think fourth matter, was his absence from Bangladesh in that time. Again, he would have to be absent from Bangladesh, so it can't bring things any further. And then finally, my learned friend highlighted the evidence of the health issues which the appellant suffered from. Those were considered by the First Tier Tribunal judge in the context of his refusal of the Article 8 claim. And there's no appeal against that finding. And my learned friend has made the point that the Article 8 claim, that there are different considerations which apply with Article 8, and the fact that there's no appeal against that decision doesn't mean, I suppose the implication being that the fact that he hasn't appealed against Article 8 doesn't mean that these aren't important factors. But in my submission, the court can rely on the fact that the Article 8 claim was refused, and can rely on the First Tier Tribunal judge's consideration of those health issues. and can be certain that they wouldn't have made any difference.
Part of the difficulty I have with this is I don't have any clear idea in my mind about how it was said that health issues outweighed the offence. I don't know when they arose, how serious they would be, whether they would be treatable in Bangladesh, and so on. If somebody was at death's door and had very little time to live, which thankfully is not the case here, you might well say, frankly, that's water under a bridge compared to the terrible situation that an applicant is in now. But I find it difficult. I'm told it's anxiety and depression. I'm not surprised. It must be an immensely stressful period for this appellant.
Yes. Well, my lord, what I would say is the reason we don't have a clear picture on that is that my learned friend made the submissions regarding health for the first time today in his argument. So the respondent hasn't had the opportunity to consider those submissions as they should have been able to do when deciding whether to resist the permission, the application for permission to appeal. So we're at this stage now, which is
I think
satisfactory.
I thought Mr. Malik's complaint was he wasn't inviting this court to evaluate these points, but rather to say that those were the sorts of points which the FTT judge should have cited in carrying out the balancing exercise.
Yes, but to know whether that was a material error, so whether they could have made any difference at all, you need to know the strength of that evidence in my submission. Because the Secretary of State's position is there was an analysis which was adequate, but even if there wasn't, there's no way that this appellant could have won on that ground anyway. It wasn't material. And for the appellant this morning to make submissions about health makes it difficult for the court to assess those arguments. Because
And the impression I get from paragraph 84, but you weren't in the Upper Tribunal, is that the mental health issues on appeal to the Upper Tribunal at page 84, paragraphs 10, 11 and 12, was because the appellant now had mental health issues, that stopped him giving the best evidence he could as a witness. And that was not upheld and isn't part of the appeal here. I haven't seen anything, unless Mr. Malik shows us in reply, that suggests mental health was a relevant balancing consideration at the time of the FTT consideration in terms of weighing dishonesty versus current health situation.
yes, I think my understanding of Mr. Malik's submission on this point is not that the appellant was ill at the time that the dishonesty took place, but that he became ill afterward.
Yes.
And that when the court would be assessing his conduct, and then importantly at the third stage, I suppose, assessing whether there were any factors which outweighed undesirability, that at that stage the court would look at his health considerations, even if they arose after the offending took place.
No, I understand that, but I don't understand the appeal to the tribunal to have been the Upper Tribunal got it wrong. In paragraph 91, they failed to look at his health.
No, that
The appeal to the Upper Tribunal was on the basis that this was a vulnerable witness and he couldn't give his best evidence, and the tribunal was wrong in the way they dealt with him giving evidence, which is a different thing entirely.
yes. Yes, I quite
Unless
agree,
there's
my lord.
something that I've missed and that it's more than page 84, but Mr. Malik is saying no, it's only page 84, I think. Yeah.
Yes, my lord. The point, I hadn't considered the health evidence at all because up until this morning it wasn't relevant to the grounds.
It wasn't an issue to the balancing.
Exactly, exactly. Well, that is what I wish to say about 3225.
Do you say that this case comes within the category identified by Lord Justice Irwin at paragraph 46 of being a sufficiently extreme case of misconduct so that a balancing exercise was not required?
Well,
Or do you say there was a balancing exercise that was sufficient in this case? Or are you going to allow on both points?
yes, well, if my lord gives me the option, I I would like to rely on both, but in fairness, the way it was put in our skeleton was not that it was one of those extreme cases, but that a balancing exercise had been carried out. And if it wasn't sufficient, then any error wasn't material because there simply could not be any factors which would outweigh the undesirability of the conduct.
Thank you.
But the fact that the Secretary of State hasn't said that this is an extreme case should not minimize the conduct, of course. This is, as I began my submissions by pointing out, as the Secretary of State said in her refusal letter, and as the First Tier Tribunal judge held, this was a very sophisticated and complex fraud, which involved the creation of fake businesses, in effect, in order to help people obtain leave to remain. So it's a very significant, a very serious matter, which the Secretary of State, of course, takes very seriously and undermines immigration control, which is a very serious offense. Turning then to the question of whether this appeal is academic, the appellant, until shortly before lunch, had not appealed the First Tier Tribunal's finding, or not sought permission, I should say, to appeal the First Tier Tribunal's finding that his application didn't meet the requirements of Rule 276B2C. I don't think there's any dispute between my learned friend and I that that an applicant seeking indefinite leave to remain in the UK on the basis of long residence is required to meet the requirements of paragraph 276B of the immigration rules, and those include the conduct requirements. And so the fact that these general grounds of refusal may or may not apply isn't determinative. An appellant who doesn't appeal against a finding on Rule 276B is doomed to fail in his appeal. I think we're agreed on that. I think that is why my learned friend now makes that application for permission to appeal. And so forgive me if I've misunderstood, but it seemed that perhaps what the court was thinking is if the appellant has now made such an application and that's granted, then that disposes of the question of whether the appeal is academic or not.
We haven't granted anything yet. We've just heard the application and you have carte blanche to respond in whatever way you want.
Yes. Well, the Secretary of State's position is that the application should not be granted. It's not the case that an appeal under Rule 276B2C is the same as under Rule 3225, and that all the same considerations would apply, and that it can simply be dealt with on the day. The appellant could have made that application, at the very least, after permission was granted. I mean, the Secretary of State has made this position that the appeal is academic plain in the skeleton argument served back in January. And the requirements of Rule 276B are distinct from Rule 3225, and I think that's dealt with in the case of Yassine at paragraph 40. So behind tab 7, in fact, we should perhaps begin at paragraph 39. So Lord Justice Irwin sets out the context.
I thought Mr. Mount's case was that it was the same error. Now, I accept they're different, and what's personal conduct and association may be different from what's in 3225. But he's saying, whichever route you go down, you've got to look at the good and the bad. The bad is the fraud, the good is all these other factors. And he's saying there just wasn't any balancing of the good factors with the negative factors. And the first question is, do you accept that your scene applies and there's got to be a balancing exercise for 276B? And if so, is your submission that it was done, if we grant permission to amend?
If you grant permission to amend. I mean, my first point would be that you shouldn't grant permission to amend.
I
It's
got
too
that.
late.
Don't worry,
Do
do
you
not grant permission.
Well, do you want to say anything more about why we shouldn't, other than what you've already said?
Yes, I would say you shouldn't grant permission because it's not the same test, that it is different.
Yeah.
It's too late. The respondent...
It was quite a late application.
Yes, the respondent has not, and I'm not talking about myself, but my clients, has not had the opportunity to give instructions on it to consider, the respondent is a large organization dealing with many different appeals, obviously. Needs to consider carefully how the rules, its position on how the rules should be applied and so on. And for the appellant to make an application, an hour before, at the very end of his submissions, doesn't give the respondent the proper
But in
opportunity.
reality, you know all about 276B because you're the one that raised it in the respondent's notice. It hasn't come out of the blue. My goodness me, a new rule. We hadn't seen that one. You have raised it. And what he says is, well, look, I made a mistake. I should have put it in with 322. It's the same argument. Isn't that the reality?
Well, I mean, yes, we are, of course, aware of the existence of the rule, but...
So much so, you put it in your respondent's notice.
Yes, of course. But if the point I'm making is the appellant should have, way back, in applying for permission from the First Tier Tribunal, have raised it
Absolutely.
as an error. And there would have been similar but different considerations than those under 3225. And then the Upper Tribunal could have considered those arguments in light of the facts. Maybe there would have been some discussion of the medical evidence at that stage. And then this court, when considering permission to appeal to the Court of Appeal, would have the benefit of the Upper Tribunal's decision on that. That's how these matters are supposed to be dealt with, so that the respondent has an opportunity to consider not just the law, but how...
I do understand that. He should have done it in the Upper Tribunal. He should have done it here, months and months ago.
After the respondent's notice would be...
Or even before. But
even before, but you
I'm just looking at your paragraph 29 and onwards. The one thing you knew was what the answer to this was in your case, because you do say it is detailed consideration, and you set out the relevant one sentence. So I really do wonder whether, with the greatest respect, you, the Secretary of State, really are surprised by this and unable to deal with it. It doesn't require evidence. You've argued it out in your skeleton argument.
Well, we've certainly argued out that it's necessary in order for the appeal to have any
You've argued out
prospective
the two-stage thing. If you look at page 54, it's your skeleton, I think, is page 54, isn't it? That's 325, I suppose. You say you haven't argued it out for 276B. So in the respondent's notice.
My page 54.
No, you will say that's only 3225. You will say it's not 276B at all.
Yeah.
Right, so just trying to... is there anything else you want to say as to why we shouldn't grant permission to amend? You've said it's late, Mr. Malik accepts. You said you haven't had a chance to take instructions on it. We'll come on to the substance in a minute. Anything else on the why not permission?
And also it's different. So Mr. Malik will say that there's no prejudice because it's the same considerations as 3225.
Yeah.
My point is that it's not exactly the same
Okay,
considerations.
not the same. No. And although you anticipated it in one sense, you put forward it. the arguments, your case is that you would want to deploy arguments which you're not able to because you don't have instructions because of the late notice.
Yes, and I mean, I don't want to give away too much, but I didn't actually anticipate that my letter afraid to make the application during the hearing today.
Well, it wasn't in the forefront of his submission this morning. In fact, it was, some observers might say it was after a bit of encouragement from the bench. Anyway, so that's the...
Yeah. The key issue is, are you really prejudiced in arguing that there was in fact a two-stage exercise carried out for 276 if permission is granted? And if so, should we refuse permission or should we adjourn? So you have the opportunity to deal with that if it becomes truly relevant. Because there is fairness to the appellant as well.
Well, I'm at a risk of perhaps undermining my legal expertise. I would say that there is a prejudice to the respondent in the application in that way.
All right. So that's your...
So quite simply, you don't have instructions.
That's right.
So the position... So that's on the adjournment application. Now, what do you want to say, if anything, on the substance of the point? If we were to grant permission.
If you were to grant permission, and there is therefore an appeal extant against the findings for Rule 276B, 2C, then the appeal is no longer academic. I'd have to accept that. I can't make any other submissions on whether I can't make any other submissions on the substance of 276B, 2C because I haven't had the chance to take instructions on it.
You do, right.
Can I just ask you about paragraph 40 of Yasin, which I thought you were going to take us to underline your submission that 276 is rather different from 3225. But as you does talk about them representing discrete tests, but then it goes on to say it's unarguable they are to be equated. I'm not quite sure what unarguable they are to be equated means. So any declared policy in relation to the interpretation of 3225 must necessarily apply equally with the same effect as 276B.
I think it means
Is he
it
saying
cannot
they're
be argued.
different?
That it cannot be
They
argued.
say they are different rather than
That's what he's saying. Yeah.
That's what that's how I interpreted that paragraph, which is why I drew your attention to it. Of
Yeah.
course.
No, then I read it and I wasn't quite sure I understood it, but that's your reading, is that it's saying
Yes.
absolutely they are different things rather than.
Yes.
Thank you very much.
So you say this court should not deal with this point by way of giving Mr. Malik permission at the last minute, taking the arguments as being the same and dealing with it on that basis. You say they're not the same. You're prejudiced because of the late application, and you've got no submissions, further submissions to make on the merits of the appeal if permission's granted. Is that right?
But you go further to say if permission's granted, you'd need an adjournment because you'd have to get instructions. We couldn't possibly leave it without instructions. We'd have to come back on another day. So it's a proportionality issue.
Yes, although taking things practically, if you were to grant permission, but you were going to find that, let's say, Rule 3221A applied, and it was a mandatory refusal, then
So if you're going to win, if Mr. Millat's going to win on all points, so if you win on 3221A, if the appeal fails on that, then it would be obviously disproportionate, you would say, to allow an adjournment to take your instructions on something which isn't going to have any impact on the outcome of the appeal.
Or if you win on 3225.
Or 5.
Pardon me.
That's right. Yeah.
It's actually a 276B case. So they used the analogy of 3225.
Start off.
A 276B case. That's why.
I think that's all the submissions I plan to make. Can I be of any further assistance?
No, thank you very much. Thank you very much, Ms. Paul. Yes, Mr. Malik.
Just dealing with the last point first. You are at Yasin. If you look at paragraph 39 of Yasin,
Yes.
you've heard detailed submissions from both sides on Yasin. Yasin is a case about 276B. If you look at paragraph 39, you'll see that the Secretary of State had refused the applications both under 276B and 3225.
Yeah.
Now, when the matter reached the tribunals, the tribunal took the view that this wasn't a 3225 case at all. It was actually a 276B case.
Right.
So it isn't. And then whatever has been said in this judgment, in particular paragraph 46, is actually about 276B. You've heard submissions from both sides as to this authority. When I refer to this authority in my skeleton
You did.
and the grounds for that reason.
Well, except of course you weren't appealing against anything on 276. You were
Yes,
appealing
and
against 3225.
yes. So when Milan and Friend put in the respondent's notice, there was a response from the appellant. May I just show you that response? If you have my skeleton, my replacement skeleton, if you have the bundle, go to page 26 of the bundle. May I ask you just to look at paragraph 30 of my replacement skeleton argument. This is page 26 of the bundle. May I just ask Lords and Lady just to read paragraph 30? So that is the position that the appellant took, that I took when I received the respondent's notice. The tribunals, in my respectful submission, proceeded on the basis that the appeal is being dismissed under 276B simply because it is being dismissed under 3225. If I'm right about paragraph 3225, the decisions in my respectful submission cannot stand. When I make the application, just to formally add the words paragraph 3225 in the grounds, I mean, of course, on encouragement from the bench, but the point was made in my skeleton argument, in my permission
But your skeleton argument is not your grounds of appeal.
No, it's not. No, it's not. So
It seems to me that you said at paragraph 30 look, they're the same thing. We've just been shown Yasin that says they're not the same thing.
No.
It's not in your grounds of appeal.
no, what I said was that the tribunals took the view that 276B decision is premised on paragraph 3225 decision.
You have taken, this is what you're saying, you've taken your cue as to how to tackle this issue from the tribunal's treatment of it.
Yes,
The tribunal treated them as being ad idem,
yes,
We do.
sort of, and that's the way you've dealt with them on appeal.
yes.
So
But that of course depends on this court agreeing with that interpretation and or that the tribunal was right to deal with them as being ad idem.
Yes.
So what you're saying, 1991 at page 117, 90 says you weigh the community groups and good causes against the making of false representations, and you say that's not enough for the reasons you gave. And when he says for the same reasons, i.e. looking at the community groups versus the false representations, it falls foul of the character requirement. So you're saying it's the same balancing exercise was being carried out for both,
Yes.
one in 90 and one in 91.
Yes.
And if it's wrong in 90, it follows as night follows day. That it's wrong in 91. Is that the
Exactly.
submission?
Exactly.
I got it. Okay, it's my fault.
I'm grateful. So that is the submission. If I'm wrong about that, then that is why I make the application.
Right,
as
it's
a
only,
primary
okay,
application.
so, right.
It still doesn't matter because even if it's the same error, it's an error in relation to a different rule and you just never ever pleaded it. It may be the same reasoning leads you to find that the 276B was equally wrong,
Yes.
but you've got to say the 276B is wrong, haven't you?
Well, you have done, albeit
Yes,
late.
you have done now, yes.
No prejudice. I mean, you've heard submissions as said on Yasin, which is
Yeah.
276B case,
Yeah.
not a 3225 case.
All right, so that deals with that issue,
so the-
does it?
Yes, so the appeal in my submission is not academic. If I'm wrong on issues 1, 2, and 3, the appeal will fail. But if the court is persuaded that the two grounds are well founded, then it wouldn't be appropriate in my respective submission to uphold the decision made below simply on the basis that there wasn't any explicit or separate challenge to Rule 260. Now, a learned friend at the outset of her submissions took the court to the decision made by the First Tier Tribunal and made a submission as to paragraph 322 of the immigration rules. And my learned friend submitted that that provision only applies where a previous application has been granted. And this is the point that was made by the First Tier Tribunal. The answer to that point in my respectful submission is in the way that the rule is expressed. This is page tab 9 of the authorities bundle, page 193. The making of a false representation for the purpose of 1, obtaining leave to enter or remain, and 2, for the purpose of a previous variation of leave, for the purpose of obtaining a previous variation of leave. So you read the words for the purpose of obtaining with the words a previous variation of leave.
Yeah, but the problem is the previous variation of leave, not a previous application for varying leave, which would be the 2013 application on your submission. It would be one of the early ones because it's a variation of leave. It means the leave that has been granted.
Well, then that in my submission ignores the word obtaining.
Obtaining a previous variation of leave.
So for the purpose of obtaining, so if a person makes false representation in an application for variation of that leave, now whether or not that application is granted, false representations are being made for the purpose of obtaining variation of leave.
You know, a previous variation of leave, two things have happened. The leave, not an application for leave, but
Yes.
the leave has had to be varied, which it was prior to 2013, and that previous leave was obtained by, or false materials put in for the purpose of obtaining. It's the fact that it refers to variation of leave, not application, that's the problem, if you see me.
No, I see. I mean, of course, I recognize the problem, and that's the reason I took the court to Pokrial, saying that where the Secretary of State has publicly said something about a rule or a provision, then the Secretary of State is bound by it. And then I took the court to the Secretary of State's published public policy document
Yeah.
behind tab 10 of the bundle, page 206. And I ask you respectfully to read paragraph 3222 in the light of the paragraph that you have at page 206. That page says that if false representations were found to have been made by the applicant in relation to a previous application, that's it. Whether or not the application is granted, whether or not there is previous grant, then the current application should normally be refused. So it's perfectly open in my respective submission to the Secretary of State to refuse. It was open to the Secretary of State to refuse the 2018 application on the basis that there was reception in the 2013 application. But even if I'm wrong about that, as Lord Justice Lewis pointed out, it was always open to the Secretary of State to refuse the 2018 application under paragraph 3225 of the immigration rules on the grounds of previous deception. Now, my learned friend then made certain submissions on paragraph 3221A of the immigration rules, and she submitted that this is page 192 of the authorities bundle, that making of a false representation is a matter of utmost seriousness, and false representation lead to a mandatory refusal of an application, well, whether or not material to the application, and whether or not to the applicant's knowledge. And that was the premise of our submission, that this provision applies in the present case. But in my respectful submission, and there is an authority as to that in the bundle. If you look at the rule in question, page 192, so the words that appear in brackets, whether or not material to the application, and whether or not to the applicant's knowledge, those words relate to false documents or information as opposed to false representations. So if a person submits a false document with an application, then that results in automatic mandatory refusal, whether or not material to the outcome, and whether or not to the applicant's knowledge. But the question of false representations is different. There is no automatic or mandatory refusal, whether or not material to the outcome, or whether or not to the applicant's knowledge, so far as the false representations are concerned.
So the phrase in brackets qualifies the documents or information.
Yes.
When we looked at this.
But he did give false information, didn't he? Because didn't he suggest that he'd been an entrepreneur and he'd been involved in business activities, and that was all documented.
Well,
that's what turned out to be false.
yes. No, there is a. Can I just take you to tab 3 of the authorities bundle? That is Adidoyan, the authority on construction of this particular rule.
Right. So you're going to cite an authority to support your interpretation.
Yes. So this is Adidoyan. So this is where the court considered proper construction of this particular rule, paragraph 3221A. And if you look at page 56 of the bundle, under the heading discussion, the precise issue before the court was about the meaning of the word false in that rule. And if you look at 67.
So is the rule set out anywhere? It's hard to make sense of 65 without seeing the rule.
Rule 3221A.
Same wording.
What's the same wording? Is it okay?
It's the same wording, yes. It's paragraph 2 of the judgment. That's the same wording. But the point that Law Justice 6 was making at paragraph 67 and 68 was essentially that there is a difference between false representation, making a false representation, and submitting a false document.
Well, let's just look at what he says. Do we need to worry about what Lord Justice Stoltman says or not?
No, this is paragraph 67 and 68, pages 56 to 57.
Should we just read this section?
Yes, great.
We'll just sit down for a moment, Mr. Malik, while we do that. I'm going to read from 65.
67 and 68, essentially.
Right. Well, thank you. Does Lord Justice Ricks say in terms that the words in brackets only qualify false documents or information? Or is that an inference you're inviting us to draw from the distinction he makes between 67 and 68?
Well, it's really 67 and 68, and there isn't anything more expressed on the point.
He treats the two, false in the documents and false in the representation, as meaning the same thing because it's natural to align the two.
Yes.
And because it requires dishonesty in one context, it's likely to require dishonesty in the other context, although not necessarily dishonest
yes.
by the applicant.
Yes.
That rather suggests the two are different sides of the same coin. So if they're meant to be treated together, you'd expect the brackets, the parentheses, to apply to both as well.
Yes, but that's not. I mean, if a false document is submitted with an application, whether or not the applicant knows that it's a false document, or whether or not the false document is material to the application must be refused. But if a false representation is made in an application, then that does not result in automatic refusal, and there must be some consideration of whether the applicant, for example, if a representative makes an application on behalf of the applicant, and the representative gives information that is false or inaccurate, then that does not result in automatic or mandatory refusal under this
The
rule.
last sentence, that when you're talking about, as I understood it, false representations, what you're looking for is dishonesty. If you have a dishonestly false representation,
Yes.
then that's in the
Yes.
same category as a dishonestly false document.
Yes.
And whatever, I mean, it may be that we don't want to decide this as an objective matter, but on the facts of this case, there was a dishonestly false representation.
Undishonest false documents, undishonest false information.
It was all false.
Yes.
These
No.
are all
all
three
dishonest.
things.
Yes. No. Yes. So except that I was just seeking to make a general point, as my learned friend was seeking to make, that well, if false representation is made, my learned friend submitted, if I understood the submission correctly, whether or not to the applicant's, a general applicant's knowledge, or whether or not material to the application must be refused. Just sort of seeking to clarify that, well, that is not strictly accurate. It's only accurate in relation to the false document in a general sense, but of course.
I think that doesn't that go to, sorry to cut you off, doesn't that go to a different point? That's the meaning of the word false, not the question of whether, if there is false, as the court interpreted it, to mean dishonest, whether or not the thing they were false about was material, it's irrelevant. If the husband, rather than the applicant wife, forges a marriage certificate, there's a false representation. It doesn't matter ultimately whether it's material.
That is a false document. If it's a marriage certificate, that's false.
They're interviewed and they say we've been married for years, and they haven't actually. They've lived together, but they haven't been married, and they know they haven't been married. That might be a false representation. It may ultimately not matter.
Yes.
But isn't this all about the Home Secretary being able to say to people, if you want leave, you've got to be honest with us. And if you're not honest with us, whether or not it matters, the fact that you are not honest about what you say or what information or documents you provide means you won't get what you're asking for.
Yes. So the
Old-fashioned language.
well, if for example, husband makes an application for himself, and the husband also makes an application for his wife, that is the wife's application where the husband has made it. In that application, husband has said something that isn't accurate. The wife doesn't know anything about it. Now, that will be a false representation, but not to the applicant's knowledge. And that, again, not this case, not a point that my lord and my lady has to decide in this case, but that wouldn't be a case where the application of the wife will fall for mandatory refusal, because although the information in that application is false in the sense that it's inaccurate, the wife whose application it is not dishonest.
Now, what Lord Justice Ricks was doing in this case was querying, I think, something said by Lord Justice Staunton a long time
Yes,
ago
in ACTA.
in ACTA, where he, and this is at page 41, paragraph 8 in the Antidoyan judgment, which is that in the context of immigration law, false representation has been thought of as being used in the what is it's called the morally neutral sense.
Yes.
So, in other words, inaccurate rather
Yes.
than dishonest. And Lord Justice Ricks was challenging that.
Yes, and he ultimately took the view that false means dishonest in this context as opposed to merely inaccurate.
And what's happened since then? So we have two conflicting decisions by eminent commercial lawyers about the interpretation
This
of
is,
immigration law.
Yes, Antidoyan is now well settled. It has been
Was it approved by
in
in
Pokreal.
well, it was cited in Pokreal, wasn't it?
Yes.
And followed in Pokreal in another respect.
Yes. And this court has since endorsed Antidoyan in a number of
Well,
other.
at this point, when you say endorsed it, is it
expressly that
this
dishonesty.
distinction? False in this context means dishonest.
Yes. So this.
All right.
this
Well,
this
that's
court-
very interesting. But in this case, there's no issue, is there, that
No.
the conduct was dishonest?
Balajigari, which is the model, yes, that's another case where Antidoyan was endorsed in the sense that false means dishonest.
Okay.
But in this case, there's no dispute that the appellant made false representations and
right.
he was
And
dishonest.
submitted false documents. And submitted false information. Or his agents did it on his behalf.
Yes, no,
The bank accounts, the company accounts were false.
Yes, Lord, I said that I won't underplay the conduct of the appellant, but the finding against him is that he made false representation. That's all.
So how does this? So you must remember this is a response to a point made by
Yes.
Ms. Pottle. What's the response?
Well, Miller and Friend, I think, was seeking to submit that making a false representation is such a serious matter that it calls for mandatory refusal, whether or not false representation is material to an application, and whether or not it is made to the applicant's knowledge, and that, as she submitted, if I understood the submission correctly, justifies reading paragraph 3221A in the way that she has put forward, namely that even if there was false representation in the original application, that justifies refusal of the application as varied. And I was simply seeking to submit that it's not as straightforward as that. It's only the dishonest false representation that results in refusal of an application.
All right. But in this case, we have a dishonest representation.
Yes.
We have false in the dishonest sense
Yes.
of documents.
Yes. Yes.
They were material to the original application, Ms. Pottle says, and therefore to the application at all times. So the point doesn't really affect the argument, does it?
No. I mean, of course, the facts are not relevant when it comes to the construction of paragraph 3221.
You're saying the fact that there could be one situation, a false representation, which was not material to the a false representation, but it wasn't material. The fact that that wouldn't justify mandatory refusal shows that you can't assume that anything false, representations or otherwise, is serious, and therefore there's nothing wrong, you say, with taking it into the discretionary rather than the mandatory refusal. That's your basic point.
That's the point. It's a general
policy force.
I'm grateful.
Yeah.
Yes. I'm grateful. So you have, Miller and Friend took you to JHAT, Zimbabwe. The court has seen paragraph 35. Second last sentence is the paragraph that I highlighted in my opening submission. Miller and Friend took you to that sentence too, that any decision on the application will relate to the application as varied. This is what paragraph 35 says. Now, and that's how I respectfully invite the court to read paragraph 3221A. So the words "the application" in that paragraph, in my submission, means the application as varied.
No, it doesn't. I thought you wanted to say just the new application.
Yes, and yes, so
Yeah.
so the decision must relate to that application, the application that is the new or a
Yes.
varied application. Um, just finally on paragraph 3225. Now, my learned friend submitted that I won't take more than
No,
more,
no,
more than a
no,
couple of minutes. So my learned friend submitted that Balaji Gari was a very different case. She said that so was Yasin, because Balaji Gari was a case about
late tax
discrepancy in the
returns.
tax returns. That, with respect, isn't the case. Balaji Gari was actually a dishonesty case.
Okay.
If you look at paragraph 4 of Balaji Gari, you'll see why that is the case. Tab 6, so paragraph 4, page 96. So the Home Office became concerned that Tier 1 migrants were falsely inflating their earnings. So it wasn't simply the discrepancy in the tax returns. An applicant would say in an application to the Home Secretary that his earnings are, say, 40,000, but to HMRC they would declare earnings as 4,000. The Secretary of State said that they were dishonest in their Tier 1 applications because they falsely inflated their earnings. This is paragraph 4. If you wish to see the decision taken in that case, it's at paragraph 111, page 121 of the bundle. It's quite clear that that was a dishonesty case. The Secretary of State said that the applicant was deceitful and dishonest. So this isn't merely a tax discrepancy case. It was a case involving dishonesty. Now, my learned friend invites the court to uphold the decision, even if there is an error made below, on the basis that the error was not material to the outcome. The outcome, my learned friend says, is inevitable. Now, this is the sort of argument that the Secretary of State made in Balaji Gari, invited the court to dismiss the appeal, notwithstanding the errors, on the basis that the outcome was inevitable. It was obvious that the applicants were dishonest. Well, that submission was rejected. And may I just show you paragraphs 134 and 136, where yes, paragraph 134 and 136. This is where there is a discussion as to the circumstances in which it would be appropriate to decline to grant relief on the basis that the error alleged is not material.
Yes.
And you'll see at 135 that the court should observe great caution in refusing relief on the basis of immateriality. And then you'll see what was said in the Cotton case, and then how that paragraphs end by reference to Manning, that the test is one of inevitability, and that probability, even a high probability, is not enough. So my learned friend, if there is an error of law in the decisions made below, my learned friend needs to persuade the court that the outcome is inevitable, there is no room for a different outcome. Now, when I referred to the medical condition and other factors, I made reference to that in answer to a question by my Lord Justice Lewis as to what else was there. I'm not asking the court to sit as a first instance tribunal and to conduct a balancing exercise. I simply highlighted those factors just to tell the court that those are the sort of factors that a tribunal will look at when conducting the balancing
But this
exercise.
tribunal was never, in fact, asked to look at them in that context. So this tribunal can't have made an error by not weighing as part of, or considering as part of the two-stage balancing exercise, the current state of the applicant's mental health, because it wasn't put on that basis. It was put on his ability to give evidence being effective.
The medical, of course, absolutely, yes.
But not the others.
No, and the ground, the challenge is that the two-stage balance, there wasn't two-stage balancing exercise by the tribunal. And if I'm wrong about that, the appeal fails. if I'm right about that, then I sort of highlight those factors that if the matter goes back,
If it goes back, there might be further additional factors to put into the balancing now if there's been a declining mental health situation.
yes,
But in deciding whether or not there is a balancing exercise, we have to look at whether or not the tribunal properly balanced the factors in play at the time. And at the time, one of the factors that were in play was not the mental health, but the others you say were.
yes, but my complaint isn't that the tribunal hasn't taken X or Y into account. The complaint is that there wasn't
No
a proper
balancing
balancing
exercise.
exercise. That is the complaint. Just one last final point, and that
course.
relates to what Lord Lawrence Baker said, that whether this case falls within the exception that was identified in Yasin,
Yeah.
whether the facts are so obvious that that a balancing exercise was not required. So I ask you respectfully to look at the Upper Tribunal's decision. The Upper Tribunal did not say that the facts of this case were so obvious that a balancing exercise was not required. The Upper Tribunal said that there was a proper balancing exercise, and this is paragraph 47 of the Upper Tribunal's decision, page 73 of the model.
Yes.
Unless I can insist on whether these are my submissions.
Well, thank you both very much for your help in this interesting case. Thanks also to those who sit behind you for the work that they've done in support. We're going to reserve our judgments. In due course, you will receive a draft of our judgment. That is so that you can point out any typographical or other minor factual errors. It's not an opportunity for re-arguing the case. Please bear in mind the rubric at the top and the warning at the top of that draft. It's confidential to the parties, to lawyers and their parties. Any breach of that order would be a contempt of court. We'd be grateful if you would, when you submit your typographical corrections, also submit a draft order which reflects our decision. In the event that there are any issues between you on subsidiary issues, we will deal with those on the basis of written submissions. Thank you all very much.
All right.